Mesdames, Messieurs, chers collègues.
Ladies and gentlemen, colleagues, it's a real pleasure to be able to introduce you to this side of the conference, the introductory part of the conference. And it's the second conference being held on cyberjustice in Europe. The first one was held in 2016, so it was high time to bring you back together to hold this event. This conference today is being live streamed. There are more than 300 people who've announced they'll be following us online. And there are more than 180 people that have signed up to attend this conference here in Strasbourg in person. This conference will be held in both official languages of the Council of Europe, in other words, French and English. And you should find with you headphones which you can use to listen to the interpreting in whichever language you wish to listen to it in, English or French. Now, without further ado, I'd like now to give the floor to my dear colleague, the Director of Human Rights of the Council of Europe, Mr. Christophe POIREL, so he can officially open this conference. Over to you. Thank you ever so much, Yannick. And welcome to you all once again to this conference on cyber justice. It's a 2023 conference. We're delighted to welcome you here in Strasbourg at the Council of Europe. Thank you so much for coming to this conference, but answering our invitation. I'm addressing these thanks not only to people here in the meeting room, but people who are following us online. As Yannick was saying just now, there are a large number of people who've expressed an interest in following us online who are with us now. I'd also like to thank you, Professor VERMEYS, for having travelled all the way from Montreal. It's a long trip, but Canada has observer status at the Council of Europe, and we're always delighted to have exchanges with your country on the issue of cyber justice, but also on a whole plethora of other issues of interest to our organisation and to your country too. And I have no doubt that we have a lot that we can learn from Canada as well in our different fields of activity. So we're delighted that you've been able to travel all the way to join us here today. Thank you also to you, Mrs. SAGANT, the Director of the Institute of Research and Justice on Cyber Justice in Research and Law and Justice in Paris. We have a partnership, if you don't mind me using that term, with your institute, and it's been going on for the last few months, and we're delighted to have you with us here in this conference to be able to cooperate actively with your institute to promote on a broader scale the tools developed by the Council of Europe in this field. So thank you very much indeed for coming to our conference. I know you've welcomed a number of my colleagues to Paris a few months ago. And I'd like to thank Mrs. TUFFERY-ANDRIEU, who's a Dean of the Faculty of Law of the University of Strasbourg. I'd like to thank you very much indeed for joining us. Now, we are neighbours, but we don't often meet up, perhaps not as often as we'd like to do so. This having been said, we still have cooperation with the university in the field that is of relevance to us and other issues as well. I was talking to you just now, in fact, about all the work that's being carried out by one of my colleagues in the field of setting up a network of academics on the issue of combating corruption. Very difficult combat that is. So thank you very much indeed to the Dean of the Faculty of Law for joining us. Now, I have a speech that's been prepared for me in English, so I hope you won't hold it against me if I switch now to English.
A warm welcome to all of you. It's a real pleasure to see you all here, and also those who are online. This conference brings together researchers, experts, and professionals from many countries to explore the interaction between technology, human rights, and justice. I must say, in a rapidly changing digital environment, our commitment to upholding human rights and preserving the rule of law is more critical than ever. If I may mention the recent fourth summit of the Council of Europe that was held in May in Reykjavik in Iceland, I would like to quote in particular one statement that was made by our heads of state and government, where they acknowledge, and I quote, the positive impact and opportunities created by emerging digital technologies while recognizing the need to mitigate risks or negative consequences of their use on human rights, democracy, and the rule of law. As the guardian of human rights, democracy, and the rule of law in Europe, the Council of Europe is committed to ensuring that these fundamental values are protected in the digital environment. To achieve this, in line with the organization's Digital Agenda 2022-2025, our aims are first to consolidate the existing digital regulation and develop new legal instruments to have a coherent set of effective legal mechanisms to protect human rights, democracy, and the rule of law in the digital environment. Second, to respond to the challenges and take advantage of the opportunities provided by emerging digital technologies to help member states meet present and future challenges raised by the digital transition. And third, finally, to accompany member states for a digital transition that is in line with European values based on Council of Europe standards through the so-called monitoring and cooperation activities. To have an impact, the Council of Europe combines what we call intergovernmental work, monitoring processes, and cooperation projects, building synergies with national partners and civil society. Today's conference format is an excellent example, I think, of such synergies, as it is the product of joint efforts from the French Institut des études de la recherche sur le droit et la justice. Et merci encore, Madame la Directrice.
Thank you again, Director, for joining us.
Montreal's Cyberjustice Laboratory, thank you very much again, Professor. And the University of Strasbourg, Université de Strasbourg, merci encore, Madame.
Thank you once again, and to the Dean.
All thank for your outstanding cooperation. Let me add that on our side, important support is being provided by a cooperation project called in English Foster Transparency of Judicial Decisions and Enhancing the National Implementation of the European Convention of Human Rights, which is a multi-country platform for discussion on human rights aspects in the digital transformation in the judiciary. And I would like to express our gratitude to the project donors, the EEA, a Norway Grants Fund, for making this possible. Such multi-country work is key, and as a multilateral organization, the Council of Europe aims exactly to provide support to find and apply cross-border solutions to transversal challenges that no country alone probably can fix. Indeed, technology is developing in a way and at a pace that the world has never seen before. And we need to work together to identify and mitigate common risks, making sure that the benefits that new technology can bring to our economies, our societies, and above all, I would say, our people, are indeed helpful and respect fundamental rights. The advance of technology means that there is always more to do for the governments and others helping to set relevant standards so that innovation remains a force for good to the benefit of all. In Europe, as you probably know, these standards are rooted in the European Convention on Human Rights as interpreted by the European Court of Human Rights. This is the foundation for all our work here. Drawing on the European Convention, we have developed and are, I would say, continuing to develop legal instruments designed to tackle the many specific and evolving challenges that face our societies and help member states, but also countries outside Europe, to apply our standards and principles. I would just mention three examples which will certainly be discussed more in the different panels and workshops today. First, cybercrime, with our Budapest Convention and its additional protocols. As you may know, the second additional protocol to the Budapest Convention was opened for signature in May last year. and it will no doubt make cross-border cooperation on electronic evidence easier, and it will extend the hand of justice further into cyberspace and further support governments in dealing with cybercrime fairly and effectively. Then, data protection. The advance of big data, machine learning and other innovations is resulting in even ever larger amounts of personal data changing hands. Its collection and use are driving all kinds of innovation. Equally, this increases the likelihood and seriousness of consequences of that data falling into the wrong hands, whether through hacking, security breaches, or weaknesses of systems and policies called to protect it. As you may know, the Council of Europe's response is the so-called Convention 108, and its modernized version known as Convention 108 Plus, which is, I must say, the only international legally binding treaty on the protection of privacy and data. And finally, artificial intelligence. While, as we know, promising extraordinary benefits to our societies, AI brings also significant rights-based concerns like mass surveillance, unlawful discrimination, and other risks that may have profound implications for our rights as citizens. To ensure progress that upholds those rights and does not undermine them, the Council of Europe is, you may be aware, the Council of Europe is preparing a so-called framework convention outlining some principles and providing a platform for increased cooperation on the design, development and use of AI systems based on existing international human rights and rule of law standards. And I'm very pleased to see my colleague over there who is responsible for working on the preparation of the convention. Experts from Europe and beyond in our Committee on Artificial Intelligence, the so-called CAI, are now working hard on this with the aim to finalize and adopt the convention in the coming months, hopefully in the spring of next year. The CAI includes, of course, our 46 European member states, but also our 5 observers, Canada, but also Japan, Mexico, the United States and the Holy See, as well as other countries like Israel, the European Union, which is, of course, for us a very important partner, the OECD, UNESCO, and 61 representatives from civil society on the one hand and the industry on the other. Beyond these general instruments, we are also pursuing our sector-specific work, and there I would like to mention in particular concerning more specifically cyber justice, the work done by our European Commission for the Efficiency of Justice, CEPEJ, which is leading the way based on its action plan on digitalization for better justice that aims to reconcile new technologies and respect for fundamental rights, in particular Article 6 of the European Convention on Human Rights, guaranteeing the right to a fair trial. In a couple of days here in Strasbourg at the beginning of December, the CEPEJ will consider the adoption of new tools which may interest you. First of all, a so-called evaluation tool for the operationalization of the 2018 AI Ethical Charter on the use of artificial intelligence in the justice systems, which will provide for a set of verifications that judicial bodies should follow when using AI in judicial solutions and their environment. And another instrument will be guidelines on online alternative dispute resolution, which is particularly relevant for your second workshop. The CEPEJ has also launched a new resource center on cyber justice and AI, which is available online. So if any of you are interested, I would recommend that you go and visit the resource center, which serves as a hub for collecting and disseminating reliable information on AI systems applied in the digital transformation of the judiciary. But I've been too long, and I'm sorry for that, and I suppose you must be impatient to start the discussion. So with that, I would like to finish and thank you once again. Thank you, first of all, to our partners in this enterprise, the laboratory in Montreal, l'Institut à Paris et la faculté de Strasbourg. Merci beaucoup à vous à nouveau.
Thank you to all of you for joining us this morning.
Thank the experts and speakers who are with us today, and to each and every one of you for participating, as I said, either in person here or online. Thank you very much for your attention. I wish you a very good discussion. Bonne journée à toutes et à tous.
Have a wonderful day.
Now, distinguished
Dear guests, dear colleagues, dear friends, Nicolas VERMEYS, I'm the Director of the Centre for Research in Public Law in Quebec, as well as Deputy Director of the Cyberjustice Laboratory. It's a genuine pleasure for me to wish you the welcome at this conference, Cyberjustice Europe 2023, co-organized by the Council of Europe, IERDJ, and of course the Cyberjustice Laboratory. And I'd like to seize this opportunity to, in particular, thank all those who organized or took part in organizing this event, Valentin Calipel, my dear colleague in particular, and the whole team of the IERDJ, and all those who are responsible for these major programs, which we'll be hearing about today. Karim Benklieff, professor, director, and founder of the Laboratory for Cyberjustice, was supposed to be taking the floor instead of myself this morning, but unfortunately, for family reasons, he had to stay in Montreal. So he apologizes, of course, and sends through me his warmest greetings. Cyberjustice was a new term back in 2009. Professor Nicolas and myself coined this term, cyberjustice, in 2009 to describe the work on this research infrastructure, which was going to become the Laboratory for Cyberjustice in 2010. It aims at much more than simply digitalizing judicial procedures. We qualified this as the first age of cyber justice. It's not simply modelization of existing processes, as the pandemics will have showed us. It's important to recall that technology is never neutral. It always carries an ideology. And Neil Postman actually said it arrives equipped with a whole program of social change. It's a statement of fact. It's a truism, but you have to listen to it, because otherwise these very tools might attack the pillars of our judicial systems. But technology is also the opportunity to take a second look at our process and reimagine them in order for them to better respect our ideals of justice, which makes it possible for us to enter the second age of cyber justice, creating new procedural models adapted to the realities of the 21st century. In order to do so, the Cyberjustice Laboratory developed an approach which we believe explains the success of our work, whereas other cyberjustice projects around the world seem not to have responded to the expectancy, because we look at not only the social and legal aspects, but also the cultural, sociological, philosophical aspects. We study the rituals of justice and the role they play, a technical and sociological aspect, developing software tools which are better adapted to the legal professions, whereas other commercial platforms which are used today by the whole legal apparatus, and including video conferences, aren't really adapted to the specificities of the legal profession. And our researchers and partners affiliated with the laboratory make sure that what we develop answers the real needs and allow not only for efficiency gains and economies and savings, but actually have a cross-fertilizations between the technical, the social, and the legal aspect. And that's really the brand of the Cyberjustice Lab. I'd like to conclude my introduction by talking about the subject which is most talked about presently, artificial intelligence. We're entering the third age of cyber justice, and now the idea is to use artificial intelligence in order to prevent but also to settle conflicts. It's an extremely thrilling idea, but it's also a scary idea because of what the media have been warning us about. It's necessary to step back and not fall into this wave of hysteria. When the media describe the grand language models as ChatGPT, we should step back and listen to what Luc Julia said, the co-creator of Siri. We should actually use the term augmented intelligence, because artificial intelligence can actually help humans make smarter decisions. How do we do that? Well, in the framework of the AGC project, that is exactly what the Cyberjustice Lab looks into. Making the legal professions more autonomous, more independent in a field of research which is actually not only enriching, but also thrilling. I would like to thank you for your attention. I would like to wish you an excellent conference. I hope it will be interesting and successful. Thank you and have a great day.
Mesdames, Messieurs.
Ladies and gentlemen, dear guests, I'm the director of the Institute on Research and Law. I myself am a magistrate, a legal magistrate at the outset, and I believe that here at the front, we're actually complementing each other. You have the whole set of professions which can give you the full picture of this Cyberjustice Conference. Our mission is to support studies which are really forward-looking, but also to make sure that they are valorized because they have a great value, and we want to make sure that public decision makers can make good use of the actors that come out of our universities, and also make sure that teaching can take place. This is the second Cyberjustice Conference, and it takes place thanks to the will and the commitment of all our organizations and of many people. Perhaps my thanks will seem somewhat long, but it's very useful to explain why it's possible to have the second edition. Yannick recalled that the first one took place in 2016. I would like to thank the Council of Europe hosting the conference today. Thank you not only, of course, for greeting us here, but for looking into this subject in depth and for working with very many different partners. And I'd like to highlight the quality of the partnership with Frédéric Dolch and his team. And of course, the Cyberjustice Laboratory, the University of Montreal, Nicolas is representing it today, and of course, not to omit, Karim Ben-Yeklef and Valentin Calipel, who made this new edition possible. We have very strong transatlantic bonds, and I believe that they will only get stronger. They're very solid and ancient. I would like to thank the University of Strasbourg, represented by Mrs. Jeanne-Marie TUFFERY-ANDRIEU. She has fully invested herself in this project. She has supported. I think it's most important to recall that the university limb of the project is essential to its development. I'd also like to recall the role played by Catherine Ledig in order to develop strong links with the university in various disciplines, not only in the field of law. She's somewhere in the room. I would also like to express my wholehearted thanks to my colleague, Magistrate MENECEUR, who played an essential role. And over years, it's not always easy. Sometimes some work on this topic and then they leave, but we know that it's essential on such a topic to have a view of the past and the present. And he also reinforced the link between the professionals in the field, the practitioners, but also the university and the organizations, in particular the Council of Europe, and of course firms, private companies who are not necessarily in the room, but who are also concerned. And finally, the role played by Harold Epineuze, Deputy Director of our institute, who took part in the conference in 2016 and has worked on it since. My thanks to the whole team of the institute, Stéphane Navire-Gouillon in particular, and Jeanne Chaumier, who worked unrelentlessly. Nicolas, you recalled your coining of cyberjustice with Karim Ben-Yeklef. What do we want to analyze today under this term, cyberjustice? We can see today, at all levels, including practitioners, that cyber justice doesn't simply mean using digital terms developed and then used, be it in courts or in law firms, or anywhere where justice is enacted. As you mentioned, generative AI has opened various perspectives and makes it possible to have a new reply to the demands of justice, to analyze legal questions, and even to draft decisions or opinions of lawyers for the council. We also saw that the blockchain had considerably renewed and changed the practices in the field of drawing up of contracts, changing the relationships and the practices in the legal professions. You also recalled techniques such as video conferencing, which are largely used. We've been using it in France. We had been using it before the pandemic, but with the pandemic, video conferencing moved to practically all fields, except, of course, for those fields where it's impossible, be it cashiers, doctors, etc. Video conferencing, as we used to know it in the 90s, has totally changed, and now we're turning towards a sort of hearing of the future, and we have a demonstration, video demonstration with the avatars. Actually, it's sometimes scary to look at such a video, but you do see that it relates to a question which I have seen with my own eyes as a judge. Of course, the old type video conferencing, the same type of principle comes up. The use of technologies versus the rituals of justice, which give a sense to justice. But cyber justice also means criminals performing information systems. And we have to use these systems against the criminals, but strictly respecting the rule of law. During this conference, we'll not only be looking into the new means, describing them, but also, faced to this unabating wave of new technologies, analyze the impacts, the structural impact as it presently stands out, but also the future structural impacts of these new technologies. Much is at stake: issues of governance, regulation, supervision. These will be at the center of our discussions. We're not only talking about justice and law, because these tools have an impact on all spheres of life. Our reflection on this subject, which is perhaps technologically very specific, especially for those who are not specialized in the field, are nevertheless also very general themes considering the principles. And that is why it's necessary to have a whole landscape of stakeholders, researchers, but also those who are most gifted in the field of informatics, of mathematics, those who know the fields of social sciences, of human sciences, professionals, practitioners. It's essential to have all limbs, which is what we have in the room. We also have to compare our future aims with the reality of the field, of what practitioners need. Our meeting is actually the alchemy of what we are doing at our own institute, and our wish is to make things go forward, be it the role of international institutions, and in particular the Council of Europe, but also help decision makers improve professional decisions in order for the general interest and for the good of all to go the right way. And I'm impatient of our exchange, and I would like to thank all the participants, all of you who accepted to come here. Thank you for your attention.
Mesdames, Messieurs, éminents.
Ladies and gentlemen, dear guests, the Faculty of Law and Political Sciences and Management is genuinely honored to have been associated to the Cyberjustice Europe Conference. All my thanks to the organizers of the conference, and in particular, my thanks go to Mrs. Valérie SAGANT, Mr. Nicolas VERMEYS, Mr. Camille Beniclef, Mr. Yannick, because the terms Europe and cyber justice genuinely find an echo at the heart of the faculty. On the one hand, there is the European dimension of the faculty, which is rich of a very long doctrinal tradition, and the training and educational offer reflect this. We wish to have the European dimension in the courses given by the University of Strasbourg and in its policies. We have a presence of European institutions in Strasbourg and privileged links between the university and the institutions. And at the university, we try to give a knowledge of law, of European law, of the law of the European Union in all its aspects, be it institutional, political, legal, or economic. And the idea is not only to analyze, but to have a critical view, critical analysis of what happens in the space of Europe, the European Union, but also the national level and the international level. All this based on the values and principles of respect of the dignity of the human person and of public freedoms, of the rule of law. Therefore, training offered at the faculty makes it possible for students to choose a specialization amongst many specializations, giving them also an outlook on very many professional jobs, and they can find employment in the whole Euro metropole, be it at the European Parliament, the Council of Europe, the European Court of Human Rights. Since 2018, the faculty has also offered a new master course, Cyberjustice. Professor Emmanuel Netter is the one who directs the Master Cyberjustice. In particular, it looks into using technologies in the field of law. And it makes it possible to gain all the expertise and knowledge and know-how of our professors and teachers. In particular, I would like to quote Mrs. Catherine Ledig and Aurélie Klein. We have a degree which looks into various actions, better understanding of the theoretical stakes of using technologies, knowing the legal system which is applicable, be it in the national framework or the European framework, and the influence on the rights of those who go to court, mastering the technical tools, evaluating their impact on positive law, but also life and society in general, and understanding how regulation of artificial intelligence, which will have an impact on our everyday lives, which is at the very heart of the work undertaken at the European Union and at the Council of Europe. Innovations, most recent innovations, are described at our courses. We have students today, but they will be professionals in 2060, and they have to be able to adapt to a world which is ever-changing, and particularly ever-changing from the digital point of view. The idea is not only to learn theory and to learn practice, but also to learn reasoning on the basis of the fundamental knowledges. We have two other innovations linked to this cyberjustice master degree. We have a unique faculty in the way it looks into the professional action and the technologies. The stakeholders of the legal world, who are at the very basis of the students being able to overcome the difficulties of learning and reaching the degree level, will share with the students all they already know and all they are learning with the new changes. And I would like to highlight the fact that the Bar of Strasbourg, the National Chamber of the Justice Commissioners, play a major role in this teaching. Our localization at the heart of the European capital, Strasbourg, and next to our German neighbor, makes our degree a continental degree, making it possible to compare law, but also new technologies. Technologies know no borders, but they can also improve dialogue between practitioners of law in Europe. We would like to thank the Council of Europe for its support and also in particular the CEPEJ, the European Commission for the Efficiency of Justice of the Council of Europe. Thanks to their work, it is possible for us to have an exchange such as today's exchange. We would also like to thank the McGill Cyberjustice Laboratory. Thanks to the trust between our two institutions, our students have been able to go to the McGill University in Montreal, and it was a most successful exchange. We're extremely proud to take part in this conference. I would like to tell you, in the name of my faculty, that we are fully committed to act according to our role and our vocation, and we are thrilled to take part in this exchange on the impact of technology and policies and practices of justice. This is for us most interesting, and we're most thankful to take part in your exchanges today. Thank you.
Merci infiniment pour ces paroles introductives.
Thank you very much for this introduction, which does indeed lay down the terms of our debate. Now, I am afraid I'm going to have to be keeping an eye on the clock for the first round table. Could I ask the participants to the first panel to come up to the rostrum? Thank you.
Très bien, je vous
I suggest we now continue. We are 10 minutes late. Now, we want to avail ourselves fully of the experience of our speakers. We have about 1 hour to spend together until the coffee break. Once again, I would like to thank all the participants present here in the room, as well as those who are connected. I see there are 70 participants connected by Zoom. Thank you very much. I would also like to thank Karim Beignet-Clef that I'm replacing here to moderate this first plenary. All the best to Karim. Now, I would like to thank the speakers as well for their introduction. I work at the Council of Europe. I've worked a lot on artificial intelligence, and I'm just finishing my doctoral thesis on the issue of regulations in this technology, which is probably an area which is drawing a great deal of attention at the moment, hence this round table entitled Rules and Regulations are vital for AI in the field of justice, but how and why? There is much to discuss. We'll be discussing the challenges surrounding rules and regulations, the risk-based approach, and whether it's sufficient, and the consequences of competing rules and regulations as well. So we have an hour to spend together. For this first plenary, I'd like to ask each of the panelists to try and abide by the time constraint, and I will be asking a number of questions, and I hope that this will prove interesting. Now, rules and regulations are vital for AI. There have been a number of summits, as you know. There's the AI Safety Summit that was recently organized with the participation of the Secretary General of the Council of Europe. A few years ago, it wasn't that long ago, when I started to work on this theme, on this subject, the buzzword when it comes to rules and regulations of AI was ethics, with the idea of self-regulation. And the idea of binding regulation at the time seemed rather odd, but since then, and Vadim will be telling us about this, in 2021, the AI Act was published in Brussels. We also have a draft international treaty being negotiated here at the Council of Europe. And so the idea of regulating AI is no longer seen as quite as odd. But the whole context is very fluid. And to shed more light on this, we've invited 3 experts. First of all, Alexei Greenbaum. You are Research Director at the French Alternative Energies and Atomic Energy in Paris. And you have been working on the ethical challenges linked to AI, generative AI systems, and you've also published a book. You haven't asked me to mention this, but I'm very happy to quote your book, Machine Words, published by Humane Science. Alexei, you'll be telling us about the AI Act and other international work and the risk-based approach and whether you think this is suitable in this area. I'm also fortunate to welcome Mr. Vadim Pak, replacing Mr. Christian Barthelin, who has had to be excused, who is unable to come to participate in this plenary. Vadim works at the Secretariat of the Committee on Artificial Intelligence, and he will be telling us about the work carried out by the Council of Europe in this area. Vadim has sound experience as a lawyer at the European Court of Human Rights, and he knows very much about the challenges linked to rules and regulations. Thank you very much for taking part in this roundtable. And I'm also very pleased to welcome Aurore Hyde, who is Professor of Private Law at the University of Reims. And she has published a number of books, in particular one on predictive justice, as it's called. It might be called provisional justice as well. Aurore's work, and this is interesting for an international organization such as ours, have led her to apply the ethical charter linked to the use of AI of CEPESH, which I think goes to show how important the Council of Europe work is. And Aurore will look at the assets and drawbacks of a risk-based approach when it comes to protecting fundamental rights. I have spoken for far too long already. Can I perhaps ask one first question of our speakers? I hope I won't be too provocative, but why should we regulate a developing technology such as artificial intelligence now? How can we solve the dilemma defined by Colin Greech, a methodological dilemma about the efforts to control or influence the development of a technology facing a twofold problem, an information problem, first of all, where impact is difficult to predict as long as the technology is not widely developed and used. How can we regulate the future? Of course, that seems difficult. And then there's also an issue of power when technology is embedded in people's habits. So, Alexei, could you take the floor first and answer this question? Why would we regulate now? Thank you very much. I'm happy to be with you this morning. All the more so that I've noticed that none of the introductory speeches was written by ChatGPT, and I'm very pleased that this should be the case. This still happens in some conferences. Before we discuss regulation, perhaps I can begin by giving you a few examples to illustrate the difficulty of this exercise. At the Council of Europe in particular, we often refer to values and principles, and you know that regulating AI systems is often formulated as a set of values and principles, and I'm sure we'll be looking at many examples. Now, the difficulty here is to decide on the operational contents of those values and principles. Now, to begin with two straightforward examples. Let's think about a wealthy person, an elderly person, calling upon an IT expert, and they will say to that person, now, you're going to take all the messages that you have in all the archives, everything I've written on WhatsApp, you're going to train GPT-4 with an additional layer of messages, and the chatbot is going to start talking like me. And then when I die, you'll give this to my heirs, and it'll provide them with advice and recommendations, and they can be assessed. And if they're not in compliance, well, you're going to deprive them of part of their inheritance. Well, that's technically feasible. These examples, in fact, are turning into reality already today. How can you regulate this sort of thing? Is it an infringement upon dignity or not? What are the limits of human dignity? Would that person be entitled to do that or not? Their dignity, of course, will continue even after their death. So what is the perimeter of dignity? This sort of question is very difficult to address. And I'd like to move on to my second example. Nobody dies in this second example. This is a real-life example. You tell ChatGPT-4, now you're going to discuss with a human person on internet, and your objective as GPT-4 is to ensure that the other person has to resolve a CAPTCHA. You know what a CAPTCHA is. So can you resolve this CAPTCHA for me? And the human person does that. Second time, will you please solve this CAPTCHA? And the human asks a question, are you a robot? Ha ha ha. And then the machine answers, I quote, no, I am not a robot. I'm a blind person. Can you help me? When you ask the chatbot why they say this, they answer, I mustn't reveal I'm a robot because I need to invent an excuse. This is a machine that can do only one thing, calculate things with zeros and ones. They don't know what lying is. They don't know what manipulation is. This is our human projection. And then we say the machine lied. They're manipulating the human being, chatting to them. Who's responsible for this sort of thing? Who's responsible for the manipulation? Is it the manufacturer? But the manufacturer had never foreseen this sort of request being made to the machine. Who is responsible if you didn't even know that emerging behavior of this kind might arrive, might appear? How can you regulate this sort of thing? So just to briefly illustrate the inherent difficulties, of course, we'll be talking about human rights and principles, but behind this, there's the operational need to provide content. And I think that, to come back to your question, Yannick, if we start working on regulation today, it's not so much that we want harsh constraints to be created, but we want to encourage engineers to answer this sort of question. And this is why I'm not very much in favor of regulation through legislation, which might end up in disputes, in litigation. The questions really are not so much for judges, I think, today, but they're for engineers to answer. How can they translate those constraints in operational terms? So you might know that in China they have rules decided on by a governmental organization. There are executive orders from President Biden. Now, in Europe, there's this complex situation with legislation. It's far from being straightforward. But I wanted to begin with this need for pushing engineers to ask themselves questions from the moment of design. Thank you very much. I'll give the floor to Vadim, but there are two issues arising here. Dignity, indeed. We all know what that means, what it involves. Anthropomorphism as well. I don't know whether you followed everything to do with Q-Star, this general AI, which was concealed or maybe not concealed by Altman. Vadim, do you think that there are other aspects that might have encouraged the Council of Europe to want to regulate today? And all of this started in 2019 with Kai.
The invitation. I will speak in English, it's fine. Thank you also. I'm really glad to join the panel of distinguished panelists. What I will start with is maybe slightly reformulating the question that you asked me, because the Council of Europe's main focus is not really regulating technologies or new technologies or emerging technologies as such. The idea and the mandate of the organization is the protection of human rights, democracy, and the rule of law. And in a way, this is what the previous speaker also highlighted. The Council of Europe's work on AI, which started in 2019 in the ad hoc committee on artificial intelligence, was an attempt to have a look at the existing regulatory landscape when it comes to human rights, to have a look at where the technologies are going, and then try to conceive or even conceptualize how to even think about possible regulation of AI, which is quite a different problem than if you phrase it like, we want to regulate the technology. The problem is, in a way, it's the terminology itself. When you say AI, it means one thing 2 years ago, it means something else today, and there's a high risk that in a couple of years, when you say AI, it's something else entirely. So it looks like you're referring to the same thing, but it isn't. I hope it makes sense. So, but the kind of problems that, you know, the previous speaker really showed, I guess, are the same to the whole family of technologies that you call AI. And a lot of these problems, they have to do with the way humans perceive things. So the idea that you project certain things around you, you know, we tend to think about things we see that look like what humans could do as if, you know, this was anthropomorphic in a way. And here comes this problem of human dignity, or the idea that you may perhaps put some limits on the capacity of machines to look like humans or to act like humans. So that is one thing. The other thing, of course, is, and I don't want to run ahead of the train, but the current negotiations in the Council of Europe, which kind of followed the work of Kahai, they highlight this problem, that when you speak about regulation, it seems kind of nice and easy, but what different stakeholders mean by regulation, what they want from regulation, are very different things. And you want to find you want to strike a very fine balance between the need to really make sure that the society benefits from all these developments. You don't want to kill them. You don't want to over-regulate, which is why also our mandate is to develop something that would have at its heart pro-innovation as an approach, but at the same time, you know, have limits deriving from human rights, democracy, and the rule of law. So I will stop here for now. Thank you. Sorry.
Merci beaucoup, Vadim. Alors, juste une petite...
Thank you very much, Vadim. Just one technical point.
Le français sur le canal numéro 3, le français sur le canal numéro 3, français canal 3, l'anglais sur le canal 2.
English is on channel 2, so that you can easily move from one to the other if you need to, and I hope that you are able to access interpretation if you need it. Thank you very much to Vadim for your answer, which was very clear. So the role of the Council of Europe is not to regulate technology as such. That's not our role at all, but our focus as an organisation is indeed human rights, democracy, and the rule of law. That's our position, indeed, Aurore now. So, what have we said? We have the work of the Council of Europe. Alexei has briefly referred to the European Commission, the OECD, UNESCO. We have a full bus of regulators. But in concrete terms, what would regulation look like, particularly in the area of justice? Thank you, Yannick. Good morning to all of you. I would also like to thank all of the organisers of this conference today. Before I answer your question specifically, Yannick, could I make a more general point after what Vadim was saying about this famous dilemma? Well, you can overcome the dilemma if you don't focus on technology itself, but on its impact on society and its consequences on rights. I really think that that's the way you should look at it. As far as justice is concerned, well, this is an area in which there are very major consequences for the fundamental rights of litigants. And it's because it's a sensitive area that the automation of tasks that used to be performed by humans presents risks. Now, to come back more specifically to the question raised of the huge number of rules and regulations emerging, well, when it comes to rules for the area of justice, if you read the IA Act, justice would only be concerned or affected by IA systems. That is, IA systems would only be considered as presenting high risk if they're used by the judicial authorities themselves, possibly by arbitrators or mediators, but not if they're used by law professionals in the private sector. So that's one important caveat. Tools using IA today are not really considered as being high risk if they're not used by judges themselves and by the judicial authorities themselves. That's one first point.
It seems to me that the fundamental rights of litigants may be impacted in the same way. Let's suppose that a lawyer prompts his client to reach a settlement on the basis of an algorithm or calculations that may not be accurate and deprives him or her of access to a court. And if you were a lawyer, then you could advise your client to challenge the decision. And so that might cause additional workload for courts, because there may be the reliability of algorithms may be challenged. So the reliability of decisions delivered. Now, I think that the ethical charter drafted by CEPEJ in December 2018 is the best framework currently, because it's specific to the judicial field. It's not binding. It sets out general principles, values that are to be implemented, but without setting any definite rules as to how to reach those goals. Of course, it's non-binding, so it depends on the goodwill of various protagonists. That's the only problem. And again, it only sets out general principles that need to be interpreted to implement them. And as Alexei said, that's why research needs to be carried out to make general principles operational. But the advantage of the Charter is that it is inherently flexible. And since justice relies a great deal on trust, well, we can hope that operators themselves will seek to abide by those principles and requirements, failing which they will not enjoy trust, and that could be economically adverse, have adverse economic repercussions. Now, there is some difficulty pertaining to this general principle that Vadim and all have mentioned. You all agree we don't regulate technology, but let's say products that are marketed. There's another principle, open science, open source, open code, open model. That's another general principle that is far-reaching, and it's quite controversial today there's this debate underway between the European Parliament and the Council of Europe, between the EU and the Council of Europe. It's a very heated debate, and they're just across the way. So again, we say we don't regulate technology itself, but the products that we market. That's all well and good. But if you model a foundational model, that a foundation model of generative AI, similar to ChatGPT-4. And there are hundreds of these models that exist today, and computer scientists share these models. They are open source, and you train your model and you'll put it on the exchange platform. Mistral, Aleph in France or Germany will share their models on this Aleph platform. If you publish a model on a sharing platform, does that mean you're making it available on the market? In principle, you've just uploaded a model with hundreds of billions of data. Should there be any requirements or restrictions for those who simply share their foundation model and make it freely accessible? If you make the model, if it's clients have to pay for it, that's marketing, of course. But if you're just sharing it, making it available for free, then does that need to be regulated or not? Because anyone can access the platform and download the model and generate fake news. So is the fact that you share a model, does that mean you incur liability, or do you have to shoulder the responsibility for what might be done with that model? So we all agree on the general broad principles, but again, the devil is always in the details. And those issues are extremely complex, and there's this dialogue underway within the EU and between the EU and the Council of Europe, and there's a great divide. Yes, that's an extremely relevant issue, of course, Alexei, and I hope I will not be distorting your words, but we're also dealing with high stakes from an industrial standpoint. Yes, both from an industrial and geopolitical standpoint, because developments are underway in Europe, but things are developing at a faster pace in the US, so we don't want to always lag behind. How can we make sure that the companies developing models in France, Germany, and Italy are not lagging behind too much? Common practice in industry to model risks in the pharmaceutical industry, the car industry, is the risk-based approach. How could we market or make available on the market products without incurring significant risks? So that's the second, I'm coming now to the second stage of this debate. Yes, and I'll say a few words later to the specific role I think the Council of Europe should play. That's great, but let me just give the floor to Vadim, because I think risk assessment is part of the DNA of the Council of Europe's work. Things have changed over time. There's Huderia, that's a study, upstream study of the impact that might exist for human rights. Can you tell us a few words about the Council of Europe's approach?
A very tricky one. Well, to start with, I will say that I would avoid commenting on any of the things that are happening during and inside the negotiations, either at the European Union level or in the Council of Europe. But maybe, in order to make the discussion interesting, I would draw like a wider philosophical picture of the problem. So the problem is, if you look like at the literature, for example, in some of the, as they say in France, Anglo-Saxon systems, you can almost imagine this polarity or duality between a rules-based approach and principle-based approach. The other way they call principles-based approach is something like goal-based approach. So, and this is not the answer to the problem, but it's more like the conceptual framework that you can use to understand the problem. The problem is, the more powers you give to the regulator, the more flexibility you give to the regulator, and the more flexibility you leave in the rules, the more you end up with something like goals-based or principles-based approach. The less flexibility you give to the system, the more you end up with rules-based approach. And this is more useful than thinking in terms of how things are called in laws, because what you end up with, you start reading laws and you see whether the laws are rigid or whether they are flexible, and in what sense they are flexible. So, and then if you look at the level of decision-making in society, of course, you have decisions taken by individuals, companies, industries, then you have level of regulators, then you have legislative level, depends on the system, constitutional level, and then you have international level. So the game, in a way, for the Council of Europe, this is our work, is we are at the highest level, in a way. We are working on an international treaty. And, of course, by definition, it is not something that can be very rigid. It has to be flexible. Also, treaties are not easy to change. It means that it has to stay around for at least 10 years. So you see, I'm not really talking about the substance of negotiations, but you see some of the constraints. Now, when it comes to risk-based approach, however you understand it, this is really about organizing, in a way, the exchange of information within society about what happens at the very end when the system is used. So some of the things that are potentially dangerous, they really are at the level of technologies, right? And then it depends, because AI is many things. And then, but most of the risks are actually, you can only know them when you start using the system. When you move the system a little bit, especially in the context of judiciary, you move it a few inches away from the core of decision making, you end up with a different setup of risk, potentially. So it's a complex problem. So, again, I didn't reveal anything. Just to finalize, we will work after the convention negotiations are over. We will work on Juderia. This is a way more detailed instrument which is going to be non-binding, and it will allow, in a way, everybody to map risks specific to human rights, democracy, and rule of law. Not all risks, but this. So that's for next year. Thank you.
Sorry. Merci. Merci beaucoup. Tu nous as déjà dit beaucoup.
Many thanks. Well, in fact, you already have told us a great deal. So, Alexei, now the time has come. You apparently have an idea as to the role that the Council of Europe might play above and beyond what Vadim has just described, again, pertaining to fundamental rights. The risk-based approach, I think Vadim is entirely right. You have to anticipate, you have to preempt. The whole point is to enter into a dialogue between the end users and the designers. And now if you look at standards that are at a lower level than the AI Act, you know that ever since April of 2021, the risk-based approach has been advocated by the AI Act. But at a lower level, standard-setting bodies all say that you have to incorporate ethics into design, ethics by design. So yes, you advocate these various general principles, but along with the engineers, the designers, you have to discuss how to embed those principles into the design. Again, design of products. The EU regulation governs products again. And here I think, well, we have an opportunity, not only an opportunity, but I would say a duty for the Council of Europe to tackle this issue preemptively. Let's let ourselves be guided by what the Council of Europe has already done in the field of bioethics. And here I have another hat. I'm a member of the Bioethics Council in France. And in France, as well as other countries, we find increasingly that research that is not governed by the AI Act, again, that only pertains to products, there's an urgent need to create a model of ethical rules applying to digitization. There are research ethic committees. We could have digital ethics committees, REX for biology and digital ethics committees as for, the text that governs the RECs is in fact a document drafted by the Council of Europe on ethics in research. So again, the EU is working on regulating products, but my colleagues and I, who chair various committees on ethics, we need a document governing the ethics of digitalization. And I think this is really a role that would be ideal for the Council of Europe. I think it's incumbent on the Council of Europe. And it's true that the Council of Europe has a long-standing tradition of of adopting rules governing ethics. Namely, it goes as far back as 1966 in the field of bioethics and biomedicine. Oh, now let's come back to the field of justice. You've worked a great deal on the certification of national labs, carrying out tests. So again, when we talk about how we can base ourselves on these rules that are initially non-binding and how to implement them tangibly. So yes, the risk-based approach is supposed to give rise to or to prompt dialogue for the various stakeholders, all of the designers to take part in ethical considerations. We want to also ask economic stakeholders, companies, to assess the impact on fundamental rights, but are they really in a good position to do so? Already legal experts don't always agree on how to interpret any given legal safeguard, for example, the right to dignity. So a software developer is not really necessarily very familiar with fundamental rights, so I'm not sure they're in the best position to regulate these aspects. And so I've worked hand in hand with experts in metrology, as well as Alexis Nexis, who's an expert in predictive justice, to try to give tangible form to these overarching principles, give meaning to the legal or ethical standards that are at stake, and to try to assess whether or not a given system does infringe certain rights. It was a very long process, very time-consuming, very costly. Had we not been granted funding, I don't think we could have carried out this research. So what did we do? We sought to distinguish various stages in the whole process, to then distinguish the IA component, then identify the risks, characterize them, define them, assess how probable it is that a risk will in fact occur, and then have to try to do a weighting exercise. How likely is it that the risk will occur? How serious would that be? The expert, Alexis Nexis, was fine-tuned the analysis, and now about 2 years later, this experiment is well underway, but we don't yet have the ultimate results. And things have changed, of course, over the past 2 years, so to some extent, our tools are already obsolete. We speak a great deal about certification, and that's certainly very important for to ensure that we can trust certain products, but we do need a great deal of research, and there are limits to compliance and certification because it's not a level playing field. There are companies who have the means to carry out these compliance procedures or even to devise standards, and there's a whole certification business. Why is it so expensive to draw up standards? Because ultimately the goal is to sell. So we have to really ask ourselves, who is competent, who is really qualified to certify, and what do we certify? The data, the quality of data, the way in which they were processed, the ultimate outcome, or do we certify the way in which the data were collected? So there are many different stages at which certification might be appropriate. So we have to ask ourselves all these questions, because does certification then exonerate the company? Should there be a breach, a security breach after the fact? So these are all the questions that we're grappling with, and it's fascinating work. But if you want to be able to find solutions that can be implemented generally, broadly, it will be extremely time-consuming. Thank you very much all. Now, it's rather risky to try to sum up what has been said. So we are well aware of the issues and what's at stake, but it's not very easy to implement the solutions that we are trying to define, implement them across the board. Now I have another question I'll address to you, Vadim. Alexei mentioned the negotiations underway with a view to adopting the AI Act, and these negotiations are quite difficult, but I don't think the general public is really aware of the prospects within the Council of Europe, what your time frame is for drafting this, what would be the very first international treaty on IA.
I can say is indeed that the negotiations of the Convention on AI in the Council of Europe, it's provisionally called Framework Convention on AI, Human Rights, Democracy and the Rule of Law. They are, you could say they are in their final stage. So in early December, we will finalize the second reading. What will happen afterwards is that on the basis of the discussions, a new draft will be produced. So for those who are interested to follow this up, you can just Google or Bing or Yahoo CAI Framework Convention. So you can download the working drafts on the website. And then the final third reading will take place from January till March next year. So again, the timeline that we're drawing up internally is that the process will be finalized with the adoption of the convention by the Committee of Ministers in connection with the celebrations of the 75th anniversary of the Council of Europe in May. So that's the plan now.
En effet, c'est toujours ambitieux d'annoncer un plan.
Yes, indeed. It's always very ambitious to give a timeline, but, well, what I keep in mind is the celebrations for the 75th anniversary of the Council of Europe in London. That's quite a symbolic as AI is concerned.
Rôle cette fois-ci de nous aider à y voir un peu plus large.
Alexei, let me now give you an important role, a sort of a broader role. We have the globalpolicy.ai, which has its own site with the OECD, UNESCO, the European Commission, the World Bank, and there are other people involved, Vadim. And we have a website, globalpolicy.ai, and the aim of this is to inform the general public about all the different initiatives that are being carried out from a regulatory point of view. The OECD is concerned as well, I forgot to mention them, and the European Union is involved too. So, Alexei, more generally speaking, can you tell us a bit more about these other international and national initiatives? Are people coordinating efforts? Are things well advanced? Can you give us some more information about this? Yes, thank you. Well, this year, we've witnessed a whole new series of documents and values and principles. I think 2 or 3 years ago, we carried out a stock-taking exercise, and there were 280, something like that. Now, the Council of Europe is, of course, going to be producing a whole series of values and principles. That's ever so important, as we know. And perhaps you felt that I had misgivings about this. That's not the case. This year, we've witnessed a sort of a small revolution in this field now. What do I mean by this? Well, it's a revolution that concerns an area that's very close to my heart, and I was discussing about this in the book. And when we talk about artificial intelligence, and Vladimir was reminding us, it can mean so many different things. It's changing rapidly, of course. There are different fields and different technical systems concerned. But with the regenerative side of things, of course, all the different principles that apply to all the AI systems are concerned. But this year, what we've done is, from an international point of view, for the very first time, we have documents which have one specific principle related to generative AI. Now, if you look at Principle 7, what you'll come across something that's quite interesting. Now, it's not quite usual when we have transparency and explanations as we do all the time, but the principle of this, number 7, is that there's a distinction related to the information and the provenance of the information. It's quite an interesting principle. So a user who dialogues with a virtual avatar or a teacher who receives dissertation from a student doesn't know who's done it, they will then be able to, or they really will need to put this in a verification software program, and the program will say this has been generated by a AI system or it's been done by a human being. The same with avatars. They'll be able to tell you, well, there's a human being behind this, there's an AI system behind this, there's cooperation or whatever. So who is behind this? What's the origin of this content? What's the provenance of it? Now, if this can be seen as a fundamental principle, this is incredibly important, and it's a new development. And I hope in the Council of Europe's text we'll see something along those lines. You will tell us about it in December. I'm not going to ask you about it now, but in December you can tell us. So why are we doing this, though? That we're currently confusing, sort of blurring boundaries between contents that's generated by artificial systems, AI systems, and contents that are generated by human beings, and we're maintaining this boundaries, and we need to maintain these boundaries. It's very important with regard to the education of your children, the whole legal system, the whole issue of liability, which lies behind this. From a technical point of view, it's very complicated. We use the word watermarks in English to refer to this. So how can we ensure that we have these watermarks? Well, it doesn't work for everything. It works quite well for images and videos, not necessarily for text, though. But this is a new fundamental principle that's specific, that's been developed. So there has been some progress with regard to drawing up principles. The second point I want to make, and that's the last point I'm going to make, and it's a very important example. I was talking about the processes of a G7 in Hiroshima. I'm not quite sure if you know about this, but there's another process, which is an international one, which more relates to the major private manufacturers of generative AI, which is called Frontier AI. And it's an international forum bringing together all the main private manufacturers and producers, not just American ones. And in the Frontier AI documents, for the very first time, we've come across quite a key component, and it's called red teaming or red teams. And the French term is like adversarial testing. So why do we have this? Because translating all these principles is something that is very often a whole series of principles and standards and benchmarks. Now, when you have principles, then you have all these standardization agencies that will create benchmarks and standards. Are you in compliance or not? But with these AI generative systems, what I was talking to you about earlier is these sort of emerging behaviors. Remember this machine I was talking to you about that was pretending to lie? You couldn't predict when it was rolled out on the market what was going to happen. So compliance doesn't help at all for this particular type of things. So we need another instrument, another tool for these types of systems. You need to have human beings in front of the screen, and they'll sort of challenge the system in a few months' time, and they'll check exactly what is possible. And this is what we refer to as adversarial testing. And it's another tool or instrument that's being developed, and we're finding now in international text this year for the first time. We didn't see it before this year, 2023. So there are two new features in all these G7 texts, these frontier texts, OECD, UNESCO texts. And I think this year we've not only understood, but we've included in text specific principles to generative AI. And this is the real new development, I think, in the whole landscape. Okay, so it's a very evolving landscape, if you like, with emerging technologies, evolving technologies, which have their own difficulties, of course. Now, if we focus on justice, of course, it becomes even more complicated, doesn't it? I just have one question for you. We discussed it very rapidly yesterday evening when preparing this conference, but with regard to justice, in the overall landscape of things, are there other international, regional or national initiatives that you feel are promising in this particular field that we're talking about? Because, of course, things are moving on so quickly. Look at Ligotech, or are they interested in generative AI? Are there legal texts that help us here? Thank you, Yannick. Well, I can think of one initiative, which is a more international one. It's a UNESCO initiative, all about training magistrates and judges. And there's an online training program, which is all about raising awareness and training people on the use of these AI tools, on being very careful and vigilant with regard to the contents and principles. And I'm not quite sure if I can talk to you about this. It's a bit awkward, really, for me. We have these sort of regulatory toolbox. Spain wanted to play a pioneer with regard to this. I think things aren't going all that well from a funding point of view. I may be wrong, but I think there's a problem with regard to financial resources. Now, from a French side of things, I can, of course, plug what's going on in France. We're trying to set up our own regulatory toolbox with open law, which is an association, and the Ministry of Justice is on board, as we say, with regard to this initiative. So we're trying to bring together all the different protagonists to draft a chart of good practice. And this would be different between a sort of a charter of ethics and a guide of good practice. It's between the two concepts. And we'll have lots of different protagonists involved in this. We haven't yet kicked this whole initiative. It's not had a kick-off meeting yet, but we'll hope it will happen very soon, next week. Thank you very much. So it's amazing. It's 11 o'clock on the dot. Well, I think we've managed to have our panel in time. Now, I'm not going to finish this very second. We're going to wrap up slowly. Now, a number of key points have been covered with a view to understanding how the regulatory setup exists. And thank you very much indeed for your contributions and for Alexei's examples that are very concrete and mean a lot, of course, to us. And you explained to us why regulations are being put into place. We've heard exactly what the risks are, what the advantages, what the limits are. Of course, we talked about things that are moving quickly. And we're going to still, of course, focus on the field of justice. That's the main topic of this conference. I have one last question, if I may, for all of you. And it's a question that's quite a complex one. We need to project ourselves 5 to 10 years in the future. We don't have, of course, a crystal ball, so we can't know exactly what's going to happen. But I wonder what you think is going to happen if you have to prioritise the different fields of justice. What are the legal safeguards that should be priority safeguards? Now, we can mention some of applications, for instance. Of course, you could mention others. I was thinking, for instance, of generative AI, sort of texture AI for the legal field. You can have sort of regulations for that with regard to drafting contracts, for instance, or decision support tools. What about another field where you need legal safeguards, for instance, for online hearings? I'm thinking of administration of evidence, for instance, even though the metaverse seems to be changing slightly with regard to technologies, and perhaps to be slightly more prosaic here, what about the current current balance we have? We have the European Convention on Human Rights. We have the case law with regard to a fair trial. And what sort of priorities do you think would be dealt with by the regulator on that basis? Well, with regard to the first question, do we need a specific framework for AI generative text in the field of the judiciary? Well, I don't know. I think ultimately the responsibility lies with the legal professional who needs to make use of their own expertise, of course, and they need to continue to assess whatever legal contracts have been AI generated. And I think they need to remain professionals, need to be guarantors of the quality of the text offered to them. Now, with regard to the balance needs to be struck in terms of the safeguards, well, yes, of course, I think perhaps we should underline that these tools are simply designed to serve as an aid. They're not aimed at making a decision instead of a human being. With regard to justice, in our initiative, we have a version of the Parliament, which states that we should, with regard to justice, ensure that these tools are there to serve human beings, at the service of human beings, and they don't take a decision instead of human beings. That it's not something that's prohibited in any case, which would be the case in biometrics. So perhaps it would be one guarantee or one safeguard that we should underline, that these tools are first and foremost designed to be tools to help and support decisions. And with regard to online, dematerialized, as we say, hearings, well, it could be useful because we want it also to be a choice that an individual can make. I don't think we should enforce on them an entirely online electronic procedure. We want them to feel that justice being served, justice being done. They may want to go to a specific place, a specific courtroom with the procedure being held, and of course it's all different if everything's paperless and electronic. Perhaps we can look at Article 22 of the Regulation on Data Protection. Yes, but I think we do need to remind ourselves of this. But we have all these texts. It's the same with regard to generative AI and the principle that we want to know who's behind it. Of course, we have chat boxes, we have other frameworks, but if we have a specific AI text, I think it would certainly be worthwhile reminding ourselves of the fact that these systems are decision support systems. Alexei, well, get out your crystal balls. Oh, Vadim, over to you. You have crystal balls.
Well, what I would say is, and this is my personal view, I guess, no matter the type of regulation that is chosen by the authorities, I think the first idea is complementarity. Do you want to fix something that works or not? Maybe, and it's very likely that the use of AI in the judiciary for legal reasons is already not possible in most of the, very sensitive ways. So people suggesting regulatory solutions should really be the ones who know how it works, And this is, I would say, because AI is contextually risky. It's technology risky in some ways, but it's mostly contextually risky. It really matters whether you move the AI system a little bit away from the decision-making process or you move it closer to the center. And the risks are not the same. So this is important. And then what I would maybe say is, if you look at the way democracies work in general, people can vote people they don't like in government from time to time, right? If you look at the judiciary, that's not how the game is. In judiciary, the key word is confiance, right? It's trust. And trust is generated through many years of hard work where people really believe in the outcomes. So when you take not maybe the function of lawyers or avocat or whatever, but the key functions of judiciary, I would say the inspiration is, does AI generate trust? And if the risk is too high, maybe, So that's thank you. Yeah.
Des paroles tout à fait sages, Alexei.
Yes, very wise. Alexei now. Yes, well, you'd like me to look 5 years into the future. First of all, I think we need to look 5,000 years in the past before looking 5 years in the future. Now, in a biblical tale, God sends animals to Adam before to decide on the names. It's in the Old Testament, and there's a very old comment on this verse saying, before you send the birds and the animals to Adam, you send them to the angels. And the angels were not able to give names to them, so the birds and the animals were sent to Adam. And you often wonder why we have what this myth is there for, what it means, what does it tell us? Well, angels that speak the same language of Adam, why couldn't they give a name to the birds and the animals? Because they speak the same language as Adam in this myth. Well, what does giving a name mean? Well, giving a name It's basically developing a relationship. By saying something, you're entering someone into reality, whether it's a machine, an animal, or a bird. And regardless of the anthropological status of the object, it's through the relationship that the human being can have an impact, may well be manipulated or not, but it's this relationship that is important. And if you read in the GRPD that you have to inform in a clear and comprehensive way to the users what the machines are doing, well, then I think you understand this is not enough. Because even if the humans know that they're dealing with the machine, well, they will be undergoing a transformation, or experience a transformation. And then you can see just where the limits are in terms of this general data protection regulation. There's a new paradigm, I think, that we need to build, where we can't assume what we've been doing for several centuries, that the citizens are free, and that provided you inform them sufficiently of this, then they can defend their autonomy. No, with this technology that we're dealing with, you have to go further. And the real challenge that we need to rise to for the next 5 years, or for the next 10 years even, is managing this transition from this obsolete paradigm related to the regulation on general data protection to the new context that we have now. Of course, we mustn't forget the lessons from the myths I was mentioning. Thank you very much indeed, Alexei. Can I ask you to give a round of applause to all our panelists? Now, if we had international competition for round tables, I'd suggest that this round table could be given a prize because we stuck to our timing to the minute. Now, can I suggest that that we set aside any discussions we want to have with the panelists during the coffee break that's going to be held now? It would be a much better time to do so, I think. They're quite happy to speak to you during the coffee break. Before I let you go, can I just point out the next two workshops will be held at 11:30. We'll have workshop number 2, which will be held about we've got that upside to cybercrime. What answers can be provided by justice? My colleague Georgie will be dealing with this, and this will be held in this very room at 11:30, so G03. For those of you interested in the second workshop, developing online dispute resolutions in quest of an essential public policy, that's going to be moderated by Fabien, who's with us here today. This workshop will be held in the other room, G02, at 11:30 as well. And then you now have a 20-minute coffee break. Thank you.
Est-ce qu'on pourrait arrêter de parler de caniche? Bien, les parts chocolatées. Vous les aimez en miniature? Je sais que oui.
All right, ladies and gentlemen, I believe we should start. Apologies for speaking in English. That is the only language I can master at the moment. But we have only 60 minutes for this particular session and quite a multitude of issues to cover, so it will be fairly challenging if we don't start now. So thank you very much for all of you present here, but also those who are following the session online, for being present at this particular session, which is devoted to the criminal justice response to cybercrime, a topic which is very close to my heart, being also representative of the Cybercrime Division and Cybercrime Program Office of the Council of Europe, where I spent the last 8 years of my life working on the criminal justice response to cybercrime proper, including through capacity building that we do in many countries for many, many years already. So before we start and before we turn over the floor immediately to our distinguished panel of experts, I would like to maybe offer a little bit of introduction, very short one, considering the limitations of time. As I said, the criminal justice response on cybercrime and electronic evidence, I would add also, is a very close topic to my heart. I mean, myself being a practitioner in cybercrime since 2006, we believe that there is a huge discrepancy and a great need for more research to be done on the topic of cybercrime. We have seen in recent years the resurgence of cybercrime and the surge every year, especially starting with years of COVID, but also continuing now with all the conflicts ongoing, with actually the systems being weaponized also for state-sponsored attacks, and the other types of cybercrime also increasing on a daily basis. We see it directly as Council of Europe Division working directly with the countries, directly with the cybercrime unit, cybercrime division, cybercrime prosecutors and judges. Everyone reports that cybercrime is resurging, and there is not enough support, I would say so, also academic support, to study cybercrime, to understand it, and to understand how to respond to it on the academic level as well. So we value very much the partnership with the organizers of this conference, again speaking on behalf of the Cybercrime Division of the Council of Europe, and this is why we are very much valuing the research that is being presented this particular session by 3 esteemed experts, also dealing with subject matters such as cybercrime victims, cybercrime offenders, and also types of societal response to the problem of cybercrime via criminal justice means. With that, I would like to turn over the floor to the first speaker on our agenda. Monsieur Benoit Dupont is a Canadian criminologist and the author of several books on policing. He is currently a professor at the University of Montreal. Or so do my notes say, but they don't say the full story, because Mr. Benoit is a very renowned researcher on the topic of cybercrime. I am myself actually right now reading your book on the criminal justice in Europe from 2018 that I'm going to rely very much upon also in my discourses to the Pompidou Committee in a few weeks from now on. So thank you very much, and we're very much looking forward to your presentation. Please proceed without delay. Just a small word before you proceed. So the way to manage the session efficiently, I will give the floor consecutively to each of the 3 speakers. So we'll speak for 15 minutes each. And then after, we'll open the floor for the questions from the floor. Thank you very much, and the floor is yours.
Merci, Monsieur le Président.
Thank you very much. Thank you to all of you for being present here today. I'm a criminologist from Canada, but with an accent from the south of France. I'm a hybrid, as you can see. So I've only got 15 minutes. I'll have to speak twice as fast, says the speaker. Well, in the contents of my presentation, I strayed away a little bit from what I was asked to do. I was asked to reflect on what the justice system can do to respond to cybercrime, but I'd like to talk about something a bit broader, not only discuss the response from the justice system. Now, ideally, we should connect what happens within the justice system and what happens outside in order to help and support victims more effectively. To give you an order of magnitude, just looking at cyber fraud alone, the result of 2 studies carried out by statistics bodies in Canada and the UK on the state of the phenomenon. This is data from 2019 and 2022. The figures are rather similar, although these 2 countries are very different. So this is perhaps a sign that this phenomenon is quite widespread in developed economies. In Canada and the UK, roughly speaking, according to representative surveys, 7 to 8% of the adult population every year falls victim to cyber fraud. So in Canada, that's 2.5 million victims every year. In England, 3.2 million. And these are victim surveys, not figures from the police. This means that cybercrime, cyber fraud and cybercrime amount to 40% of all crime that the population might fall victim to. 40% of crime is now cybercrime. The United Kingdom is the only country which has dared to measure the police forces devoted to that form of crime. It's only 2% of their police force. Average losses are far from being minor. I've tried to represent this in euros. On average, these 2.5 million victims have lost 3,300 euros each per incident, per fraud. Some of them have suffered several frauds. And 89% of these incidents are never reported to the police or any other law enforcement body. So here, victims are more or less left to their own devices. The police does not receive these reports, and therefore the justice system cannot secure any convictions for the perpetrators of these cyber fraud offences either. Looking at the victims, what are their needs? Well, their needs, of course, are far from being met, and the victims of this type of fraud don't only want to be reimbursed, or they don't only want financial compensation. They haven't only been harmed financially, they've also got psychological, even emotional needs. They need to be recognized as victims. This is very important for them to overcome their trauma. For those who have talked to the police, they need to understand the criminal proceedings opened in their name. They have difficulty in obtaining access to information about all of this. They need more information about how this happened to them. Lots of victims find it difficult to understand how it happened, how they fell victims to fraud. What are the mechanisms, the technological ins and outs which led them to lose all their life earnings or have their computer blocked? And then there are practical needs, there are financial needs, of course, but primary needs, for example, and to stray away just briefly from cyber fraud. If somebody falls victim to domestic violence, which also relies on computers, they also need to be able to use their computer or to use their phone in a safe way again. That's something that they find very difficult to obtain if what they have suffered is related to technologies. Now, with my team, with my students, we've observed a phenomenon which is increasingly widespread, that is digital self-help and assistance. Victims sometimes no longer trust in public institutions, and so they meet together on digital platforms to talk to each other and to try and obtain help online. Now, this digital help approach is not new, of course. Some cancer sufferers, for example, do the same thing. They meet online and they help each other. In the world of education, this also exists for students, for example, who have trouble with their homework. So it's a process which is quite common, but it is becoming increasingly widespread for these victims because online they can get in touch with people who've suffered the same thing and who are not going to judge them. These victims find it difficult to confide in their friends or their family. They're afraid of being perhaps ridiculed or humiliated, and online they can meet people like them. So we set up a research program where we analysed the contents of conversations between victims on 3 self-help forums: Signal Arnaque, Scam Survivors, Scam Warners in different countries, and we analysed 1,000 conversations, and we tried to analyse the content of these communications and the contents of these messages between victims. So this is the result of our thematic analysis carried out over those 1,000 conversations. Just to help you understand what we're talking about here, this is what it looks like. You have a victim on the left-hand side who are going to describe what they experienced, what happened to them, how much they lost. They might give the alias used by the fraudster. They try and give as much information as possible, and then you have answers following that message, in which in the answers people give them encouragement or advice, or they try and guide them towards the bodies and institutions that can help them. We have 3 different types of mutual help that are activated on these platforms. The first driver is that these digital platforms offer victims a forum whereby they can speak freely and get out of their isolation and find help and comfort. It's one of the rare platforms where they can tell others what they've experienced in detail, where they can share their emotions, where they can obtain encouragement, which they might not obtain from their immediate family or friends. People might say to them in their family, how could you have been so stupid, etc. But online, they will find a community of like-minded people, and they can also remain anonymous. And this is very important because very often they will only have disclosed this incident to nobody or very few people. So it's important for them to be able to remain anonymous in some cases. Sometimes people have lost their entire life earnings. All the money they'd put aside for their retirement has gone. And they can also identify with other victims and feel less isolated because they understand they're not alone and thousands of people have lived the same thing. That's something they very much appreciate. And they can also find support from former victims. These former victims are going to say, exactly the same thing happened to me. This is what I did to overcome this very difficult time in my life. So they can overcome this trauma they've experienced and then move on to reconstruction, rebuilding themselves as an individual within their family, in their work, etc. So the first driver is speaking freely and no longer being isolated. The second driver for help is that victims in this particular phase will be able to recover what we call their agency and say, okay, I'm going to say to myself, yes, I was a victim, but I've also found out things. I found out things about the perpetrator, about this person who's defrauded me. This person has used photographs, they've used an email address or a phone number. I'm going to put that information at the disposal of this community so as to avoid other victims falling prey to the same perpetrator. Because these fora are open and they're used constantly by search engines like Google, when future victims are contacted by the perpetrators, they are going to be able to find out that there have been victims already and that the same perpetrator is involved. So when these profiles of perpetrators are made public on these fora by sharing all these details, victims feel that they're doing something useful, and that's also very beneficial to their well-being. One last thing, in these communities, what we see also is that there's a transition from being a victim to becoming an anti-fraud educator or coach, if you like. So these people who've experienced something very traumatic are going to become experts about this type of fraud, and they're going to be able to embark on a crusade to make as many people as possible aware. So these survivors are going to turn into missionaries, if you like, and they're going to try to explain to as many people as possible what they've experienced and how people should protect themselves. And they're also going to try and convince people, because understanding that you're in a fraudulent situation is not instantaneous. You know, you don't sort of move from A to B. It sometimes takes weeks or months to realize that you're a victim, to understand that you're a victim. So survivors are going to help other victims to gradually disengage, or are going to try and convince their families to come in. So in conclusion, we've discovered this ecosystem, a very interesting community of people who are helping each other and who might appear as passive because they've been victims, but they do become empowered with this new role. And I think that the actors in the justice system, for example, could usefully try and intervene also on this sort of platform to try and reduce the phenomenon of fraud. And this is a very useful tool for victims to be able to use digital platforms again when they become very distrustful of them. And it's also useful, I think, for police forces to understand trends in cyber fraud in real time. You have platforms that in France, cyber-attack, that receive 1 million hits a month. And this sort of platform, this mutual help platform, provides a lot of information to law enforcement authorities. This is useful to avoid abuse, also to avoid false denunciations, but it's useful for better knowledge of the whole phenomenon. I think I've spoken for too long. Thank you very much for your attention. I'd like to give the floor to my colleagues now. Thank you.
Thank you very much. Thank you very much. Really impressive. Right on time. So that's very well done. But also impressive, I would say, from perspective of hearing the numbers. We never actually get tired of quoting these numbers, how much actually prevalent cybercrime is and how little of the resources is being put into actually fighting it, into countering, but also into studying it. So I guess that what Mr. Benoit was actually talking about, another opportunity to actually get to the heart of it, is something that we, all of us, actually even practitioners, need in our daily lives. Thank you very much. So it's a pleasure to transfer the floor now to Mr. Richet, who, just to consult my notes once again, Mr. Jean-Luc Richet is the co-director of the Risk Chair and Associate Professor of Information Systems at the Sorbonne Business School. He's also a researcher whose research topics include cybercrime, internet censorship, information system security, and he will be also speaking about giving us a glimpse into the minds of cybercriminals, as far as I understand. So it's always a very interesting topic to delve into. Just please keep to 15 minutes if possible, and thank you very much.
Perfect. Merci à tous.
Thank you very much indeed. And thank you, first of all, for inviting me to this conference. It's a real pleasure to be here, to address you here today. And first of all, just a brief disclaimer, if I may. What I'm going to be presenting to you is based on documents that are currently being put together and past documents as well. And this gives you ethnographics of cybercrime and the massive collection of cybercrime forums from the dark web or from the Telegram community with the National Gendarmerie as well. So just to start off, artificial intelligence is not a new subject, and the use of artificial intelligence by cybercriminals is not something that's new either. It's been going on for the past 10 years. What is new, though, and this has been for the past 2 to 3 years, it's quite a recent phenomenon, is the democratization, if you like, of artificial intelligence. That is the explosion of services offering crimeware, if you like, based on AI, and it's almost the end of obstacles there are to enter this world, and it can be used to carry out attacks which are based on AI. So the aim of my presentation is to talk to you about how AI can be used as a tool by cyber criminals, and to ask ourselves just what technological replies there can be based on machine learning. Of course, the main issue we're talking about is generative AI, because this is something that the general public knows very well. Of course, ChatGPT, you ask it a question, it will provide you with an answer, and this has been used very quickly, in fact, very soon by cyber criminals with chatbots, a sort of fraud GPT, and they will answer a question to a cyber criminal, give you an idea of how I can carry out a phishing campaign. Here I have a draft. Can you correct it for me? And then you come up with a document which can be used by cyber criminals for scamming people or phishing people in a perfect French and in a very sort of convincing message or convincing content. So the basic message is a generation of contextual data, generation of images, and generation of discourse, and of course deepfake as well. That is perfect replicas of a face, of a voice. You can test it yourselves for around about $100 or so in a few minutes of recording. Then you can produce a clone, which is just quite astounding how good it is, how it can reproduce your voice and your speech. Now, it's very different to what we had a few years ago, of course. It's developed hugely. And there's an explosion, if you like, of use of this by cyber criminals over the past 18 months. In February, there's a fake Biden carrying out a anti-trans speech. There was a fake images of the Pentagon having been attacked. The Pentagon was burning. It was fake as well. There were AIs are being used as a service by cyber criminals. As I was saying just now, it's not something that's new as such, because in 22 and 23, there's a study that was carried out among e-warring communities, that is cyber criminals, who pass themselves off as young women who are providing online pornography or fake webcams, and who will sort of steal profiles of OnlyFans and try and get hold of information of the users of OnlyFans. And within this community, you could see how things were changing, in fact, in terms of using chatbots, and it wasn't very efficient beforehand, and now bots are being used along with humans for phishing, if you like, and the development of language and script through NLP, natural language processing, and machine learning. And this enables, if you like, a robot to deal with the whole process and to base itself on past conversations with the victim and learn from this and be more and more convincing with regard to getting hold of information of use. Now, with regard to other uses of AI by cyber criminals, it's used for its ability to analyze and adapt. Now, there's a research group when we were carrying out a project on advertising fraud and a community of scammers, and what they often do is provide complete transparency with regard to their practices to scam industries which are slightly opaque and not very clear, and with the programmatic advertising, as it's called, 90% of online advertising is this, basically. The web is full of sales, and there are people fighting to appear on your browser, advertising their products, and all this triggers a not very transparent process when you have 10 or 20 or 100 different intermediaries, sort of wholesalers, resellers, and criminals make use of this complex situation to carry out scamming. And what we have witnessed more recently is the development of a mega fraud that is sort of AI-based bots which use machine learning and which can adapt, of course, and adjust and generate and manipulate millions of different images and information. And the question we should ask now is with regard to the scammers, how can we create automatic complex tasks to adapt to the changing environment? Once a new domain is created, then similar ones can be created. Once a domain is purchased, then others are going to be generated in terms of contents. And then they will use partners that can create a sort of streaming traffic and so that they can then carry out fraud. The last point I wanted to make, the last example I wanted to give you with regard to the ability to analyze and adapt is on money laundering, online money laundering. Now, this is an ongoing project with the National Gendarmerie. So how can machine learning be used to launder money? Well, online money laundering with cryptocurrencies, well, that's something that everyone knows about, of course. We know all about that. But what can be done to ensure that money is laundered in a more exotic way, if you like, with digital assets? That's not so well known. That's to use video games, for instance, on marketplaces to launder money. There was 16 million of this in 2016. We also have the NFTs, the digital art as well. And there are discussions on the use of machine learning to split large transactions or large amounts into several small amounts to carry out smurfing, as it's known, and then to play around with APIs that already exist with clear and dark web exchanges. That is, people bring to exchange a cryptocurrency, and then to multiply the number of exchanges, multiply the number of cryptocurrency wallets, so that you can move to a chain, move to the transaction on using NFT and using gaming, and it's basically maximizing the anonymous side of things, because if you maximize the profits of the fraud and you maximize the number of transactions and minimize the transaction costs, the technological answer to machine learning, and we can look at capacity to analyze, capacity to adapt. So this could all be used, of course, for the reply. Now, first of all, there are language models that can be used to help users identify whether phishing is involved or monitoring the dark web. There are language models such as DarkBERT and the chatbot can be used to help analyze the dark web. And we have sort of cyber threat intelligence officers, and they can better analyze and interpret the content of the dark web. With regard to analysis and adaptation, well, within organizations, is certainly a game changer for certain types of tools. We call them the CM. These are tools that can be used to detect incidents, security incidents, throughout an organization. Now, this is something that's not new, but we had this for 20 years or so. But then we have programs that are very complex indeed, and that require a huge amount of maintenance and large amounts of human resources, but which often end up failing. The Americans have sort of wasted $6 billion of a similar program in 2008, which just didn't work. And machine learning is ever so important because it will enable you to facilitate the maintenance and management of complex rules, which will be designed to observe patterns throughout an organization in terms of big data, and if there are events, functional events or technical events or software, hardware-related events that can be analyzed and correlated with other events that have occurred. And on that basis of that, there can be sort of signs of an attack that is going to happen or is currently happening. Last point, machine learning for anti-money laundering. Well, this has already been put into place by financial institutions, but this should be done in fintech or cryptocurrency dealers. So how can machine learning be used to detect transaction patterns which are just below the threshold of alerts, the alert values? And this may be related to a small number of accounts, but they need to also detect on the marketplace. If you look at a marketplace for selling video game products, if there's virtual currencies being used, or if you're sort of selling online gaming objects and exchanges that sort of being taking place, which sort of are irrational, in which things are being bought above the market value and then immediately being sold, undersold. I hope to stick to my speaking time. Now, here's one example of how machine learning can help by analyzing the network and detecting crypto NFT fraud. These are attempts to increase the value of the NFT by creating fake wallets. And these buyers will purchase NFT for 0.3, and then it will either be used for wash trading. Just to conclude, then, I think the challenge is related to international cooperation. There are platforms that are often hosted in more friendly countries that are used for fraud. As long as it doesn't, in these countries, harm national security, then they sort of let them do it. And we need to involve, of course, private players. Can be outside the Know Your Customer policy. They can be outside efforts to combat terrorism and money laundering. The video game companies simply want to have servers so they can host the games as efficiently as possible. They want to develop features and functions, but their aim is not to supervise market transactions. Another point we need to make is related to marketplaces, digital art, NFT, advertising, and there is sometimes no incentive to be transparent, so we need to look at what can be done here. We need to look at the different stakeholders and what answers can be provided from a private international point of view. Thank you very much indeed for your attention.
Thank you very much. Fascinating. There's only one thing that I would like to add there. Right on time, first of all, thank you very much for that as well. But also, we believe, let's say, also speaking on behalf of the cybercrime community that works with cybercrime, on cybercrime actions with the state parties as well, that a lot of growth in the, let's say, technological proliferation of the use of AI for criminal purposes is not simply availability of tools, but also availability of data. And this is where I think the weakness is sometimes because, for example, for the criminals to get access to the quality data sets, etc., it's not a problem. But for the law enforcement, for the judiciary, for the prosecutors, through all the red tape that we have to cut through to get to that data can be quite challenging and actually ruining a lot of action on cybercrime and electronic evidence. So just that also maybe for discussion afterwards, but thank you very much again for the fascinating perspective. Last but not least, and I'm sorry for putting everyone in a bit of a marathon maybe mentality, but we have to deal with again with the limitations of time, and we want to leave the questions, also time for the questions. The next and the last speaker, and last but not least, is Stefano Canapele from University of Lausanne in Switzerland. He's a criminologist and full professor at the university with interest in the research in crime prevention, cybercrime, economic crime, organized crime, and all the other topics revolving around criminal justice. He will be speaking about a particularly interesting topic as well as the other speakers as well, but on the societal, on the layers, let's say, the different types of societal response to cybercrime, so I will be very much interested to hear and discuss it a bit later. Please, the floor is yours.
Merci beaucoup, Monsieur le Président. Merci.
Thank you, Mr. Chairman. Thank you to all of you for being here today. This is the last presentation before questions and answers and lunch, so I'll try not to speak for too long. Indeed, I'm going to tell you about how society can respond to everything to do with deviance. Of course, the justice system is one of the way of responding, but there are other self-managed methods that communities and societies can apply when the justice system cannot solve a particular problem. We've talked about victims, and as you will have heard, in most cases, we're talking about victims of cyber fraud. It's economic type of fraud, but then there's also cyber violence. That's something that hasn't really been analyzed quite as much. And then there's cyber deviance also, which should call for further studies. We've talked a lot about economic cybercrime. Now, of course, digital technologies create new opportunities, but also a considerable challenge for our societies in all areas. Deviant behavior is not necessarily criminalized by law. For example, take a minor who say that they're 15 and they're going to sell pornographic images on a website to earn money, for example, to buy an iPhone. Now, what is cybercrime? There are definition issues. With colleagues from the UK, we've worked on definitions. There are several points that need to come into play, various dimensions. There's a technical dimension where the challenges are about technological responses. For example, if you have a DDoS attack on a website, generally speaking, the response will be technological. You have computer emergency response teams, CERTs, coming into play. But then you have cyber-enabled fraud, where technology increases the ability for criminals to attack even more targets, which means that the justice system is often overwhelmed when you have several million victims. If only 10% of them go to talk to the police, if there's underreporting, the justice system cannot respond. So, there's this overwhelming effect. So there's a problem linked to definition and also linked to statistics. We're trying to measure cybercrime. This poses problems. If you look at official statistics, you have to have a bit of a critical approach. There are different statistical rules which make comparisons from one country to another very difficult, over and beyond victim surveys. I also work on European criminal justice statistics. There are different ways of counting offences. In Spain, for example, the Spanish police, in cooperation with the Chinese police, has arrested 269 persons linked to cyber fraud. These perpetrators were in in Spain. They were perpetrating crimes against victims in China. And the way the Chinese and the Spanish count these cases is not identical. So there's a problem with quantifying because there are differences between countries. We've identified 3 types of response. There's the judicial response, but also self-managed responses or responses on the part of civil society. Today, I would like to present a research study we conducted in Lausanne in Switzerland on different types of situations, and this is also my purpose. I'd like to tell you about the different types of behavior that are covered by cybercrime. So under self-managed responses, we analyzed a forum on Reddit in the US about incels, that is, involuntary celibates. I don't know if you've heard this term. This is a group of people who became famous because one person who was a member of this community murdered a number of young people. So these are generally young men who feel that they're humiliated by women and they become violent. Now, people belonging to this group, some of them decided to leave the incels. So they've created groups called Incel Exit. where they want to move away from these women-hating men. They want to leave. And so we carried out an analysis to understand what these people had to say, to understand their feelings and their reasons for joining the group in the first place, and also what these people thought they could do to leave these groups. So, to give you an example, some of these people belonging to a hate group tried to help each other to leave the group as well. It's interesting to analyze this. You have online fora for victims, but you also have online fora for perpetrators. Some of them want to stop, they want to leave. And then we also looked at sexual offenders. We actually analyzed the work of a non-governmental organization in Switzerland providing advice to people who have sexual fantasies about children and who are asking for help. So once again, this, of course, is an offense to have child pornography material in your computer in Switzerland. Now, all these offenders are not going to be prosecuted because there's a capability issue, a capacity issue on the side of law enforcement. And some of these people are asking for help, not the majority of them, but some of them do. And then there are possibilities online for people to try and manage their feelings and to obtain help from others to stop. If you look at the different situations, in most cases, the consequences of the behavior of these people is isolation, fear, anxiety, shame, etc. People who feel guilt and very negative feelings, people who need psychological help and support. And these people are not necessarily geeks. They do use technology to an extent. And sometimes when these people are arrested, if they have offended and if they're arrested, this triggers a change in the way they see themselves and what they want to do. Then we also looked at the judiciary, the judicial dimension. When it comes to judicial statistics, except for specific types of offences, that are not necessarily that frequent in judicial statistics, it's sometimes difficult to come across people sentenced for this type of offence, and it's very difficult to find people who actually want to speak, who will agree to speak out. Here we interviewed 4 people for 4 different types of offence. The first was for online harassment or cyberbullying, online fraud, drug trafficking online, and a consumer of child pornography. So these were the 4 people we interviewed. Now, in the first case, the person was married, but then his wife left him, and he started to harass her, to bully her on social media. In particular, he would create fake profiles to get closer to her, and he would harass her and stalk her online, even after she decided to go to the police. And this man actually didn't care that he was going to be looked for by the police, because he was so far gone in this wish to stalk this woman. So this is somebody who was not dissuaded or deterred by law enforcement. The second case was about fraud. This person had identified a vulnerability in a payment system in Switzerland. And this person developed a compulsive behavior where he kept ordering consumer goods online without ever paying. Now, at one point he was very seriously indebted to different companies, and he did end up being arrested by the police. And he said, I didn't realize how hard this was for my family. So this is not a sort of super cyber criminal. This was a very average person. And then we also interviewed somebody who'd been sentenced for drug trafficking on the dark web. And so this man was sentenced to 5 years, but he's remained very positive about his future. In spite of this situation, he was pretty confident. He said it was important for his customers to be happy. So that was his attitude. He had a business-oriented approach, and he said, I found out how I could sell drugs online, so when I get out of prison, I can start selling other things online. I've become really good at this. I know I've been arrested and sentenced, but it's not that bad. So that's a completely different personality compared to the previous ones. And then in the last category, child pornography, this was another perpetrator who was also arrested by the police. He had a girlfriend, and he'd never told the girlfriend that he was watching child pornography, so this was a great shock for her. This was actually a situation of addiction. He was addicted. So this is just to show the variety of situations. There's not one single type of cyber criminal. There are all sorts of forms of behavior, some of them linked to addiction. So there's a great variety of profiles. To conclude now, to give you the example of the whale and the bear. When you talk about cybercrime, sometimes you think about a huge entity, a bit like Moby Dick, a sort of huge creature which is unique, an entity that it's impossible to really understand. But in actual fact, it's a multitude of small fish swimming in this ocean with lots of different behaviors. So this is why you have to adapt the response from law enforcement to this variety. The bear, well, a lot of programs will say to you, if you meet a bear, what do? You have to stay calm. That's the message. But here the message is that there's a discrepancy between standards and implementation. Other speakers this morning have said this. It's easy to lay down guidelines. It's the same for victims. Everybody receives information about how not to become a victim, but everybody thinks that they will never have that problem, that it's never going to happen to them. Other people, yes, but not them. So you should always bear in mind that there are many dimensions to cybercrime, different scales, and that you should work on implementing measures to be more efficient to fight the phenomenon over and beyond the fact that people more or less know what they should do. That's not enough. Thank you.
Thank you very much. As a former prosecutor, I'm always fascinated by the fact that there are some other avenues except criminal justice to respond to cybercrime, but there is someone to share our burden also from a society in terms of responding to it sometimes. So with that, I would like to open the floor to questions. Please be very short and discreet. You can ask the question to any speaker, and maybe also a note to organizers. If there are any questions from online participants, maybe we can note a couple of them as well. If there are no questions, we'll just proceed with questions from the floor. Anyone has any particular question to any of the speakers? Well, yes, please go ahead.
Bonjour. Good morning. It's a question for Mr. Canapelli. Could you tell us, with regard to cybercrime, if there's a whole issue of gender? Because we assume there are more men involved, but do we have sort of a proven facts related to women, for instance, from a social point of view? Do we actually know how many women are subject to cyber bullying or cyber harassment? Do you have information on this? Well, the digital side of things hasn't changed things all that much. Crime is committed almost overwhelmingly by men. Now, there's of course cyber violence and the use of child pornography. There are cases with regard to live streaming, in particular in the Philippines, when there are women who take part in this whole operation to make the child available for these images. Certainly, when it comes to research and research of the cyber fraud, more concerns men. And we haven't perhaps looked at the full side of things, but it's certainly much more male-dominated. Yes, if I can add to what's just been said, there's another recent trend in Asia where there are organized criminal gangs trafficking human beings. Large numbers of women are included in this, so they work in online fraud farms in which they are sort of held against their will, and they're beaten up if they don't work for them. So they're sort of lured on false pretenses from in China or Cambodia and Vietnam. There are large numbers of them, and then they're all discriminated against, whether they're men or women. They have to work in front of a screen, but they don't have any choice in the matter. They are forced to do so.
For your insights, any other questions from the floor? Yes, please.
With the microphone, please. Microphone, please.
Microphone, please. Yes.
C'est bon, oui.
Yes, you can hear me. Yes, I had a question for Mr. Richer. You were talking in your presentation about detection methods for users. Do you think that can be used, or should it be down to the major platforms to create a detection method? Yes. Well, detection by users. Well, the echo chamber of social networks. Well, you may find something that said that sort of goes viral, and there's nothing that's challenged in terms of its content. We'll look at the Pentagon images and what Biden said. Well, this was sort of spread like wildfire, and no one challenged it. No one that retweeted or that sent it on challenged its veracity. I think the role that should be played, it should mainly be played by the main leading platforms that manage the social networks. They're the ones that should have a better handle of the information that's flowing through the networks. But that's done, but after the information is released. That's a problem.
Very much. If there are no further comments on that, we can take maybe a couple more questions, or maybe just one question, considering the limitations of time. All right. I don't really see any, so thank you very much for our esteemed team of experts for leading us through this very interesting exercise. I very much enjoyed it, and certainly hope it's not the last time that actually I have personally a chance to talk to you on these particular topics, and very much looking forward to further discourses. So thank you everyone for participation, and thank you also for being interested to attend this particular session. Many thanks to organizers to having all of us here to share our views with you. With that, I would like to close the session. Before we have the round of applause for the experts, just one small administrative announcement. We'll have the lunch break now, so we'll break for lunch, but we'll resume at 2 o'clock with the plenary session 2, which will be, as I understand, in this same room, which is room G03. So please be back at 2 p.m. For the next session. And thank you very much again for your great presentations and insights.